Commissioner Plant, you have a white glow around your face like Obi-Wan Kenobi.
Yeah, I need to close the window shades behind me, I think.
Yeah, you're free to get up and do that if you'd like.
What?
Uh, Good morning. It's 9 a.m. on October 7th, 2025, and we're now on the record. This is a public comment hearing in proceeding number 25A-0266E, Tri-State's application seeking a commission finding that SPP RTO West is a statutory organized wholesale market as defined by commission rule and statute. And that Tri-State's planned participation in the SPP RTOS market is in the public interest. By rule, this is an abbreviated adjudicatory proceeding. The Commission approved a consensus process, which included scheduling this hearing as a public comment hearing that is intended to be similar to a rulemaking hearing with no cross-examination. Instead, parties in the public may provide comments, and the Commission may ask questions of Tri-State and the other parties. Pursuant to the procedural schedule, initial written comments were submitted in mid-September, and Tri-State's response was filed on September 25th. Today's public comment hearing is another opportunity to provide comments. With that, I'm Eric Blank, the chair of the commission. Can my colleagues introduce themselves for the record?
Good morning, this is Commissioner Megan Gilman.
Good morning, Commissioner Tom Plant.
Before we begin taking statements, I'd like to briefly explain how a public comment hearing works. The comment hearing is formal, like a court proceeding, and we ask that the audience be respectful of the speakers that comment today. Commissioners will not be making a decision today. We are here to listen and learn from the comments, though we may ask clarifying questions. Once we have gone through everyone who would like to speak, if no more commenters join the Zoom, we may conclude the hearing at that time. Written comments can be filed directly into this proceeding through the Commission's e-filings website or through the Commission's online comment forum or by emailing comments to dora_puc_website at state.co.us. If using these methods, please specify the comments apply to proceeding number 25A-0266E. Anyone can file written comments after today's hearings, including to clarify what was said today or to respond to anything that you may hear. Post-hearing comments are appropriate on any topic raised in this proceeding, in addition to responses to any written or oral comments. If you'd like to speak today, use the Zoom raise hand feature. Speakers can also turn on their camera if they're having trouble with that feature. I think I'd like to start with comments from the public, although looking at this list of people who signed up and people on this Zoom, it looks like it may be only parties, but we'll start with the public and then jump to the parties. But before that, Commissioner Gilman, any initial comments before we start?
Not much. Just appreciate you all being here and look forward to hearing from you all today. Thanks.
Commissioner Plant.
Yeah, same. Look forward to hearing the comments of those who are participating and appreciate you joining us.
With that, if anybody from the public who is not a party in this case would like to offer comments, can you please either put up your raise hand feature or turn on your camera? I'm not seeing anybody, so maybe we'll just go with the parties. I don't know if the parties have in order, but the list I have is Tri-State, Trial Staff, UCA, CEO, Interwest, Black Hills, WRA, and Holy Cross. So I'll just start with the company and see if you have any comments you'd like to share. We have your written comments and we have the filing and your responsive comments. So Mr. Hoffner.
Yeah, good morning, Chair. Good morning, Commissioners. Thanks for the opportunity to speak to you this morning. I am Dietrich Hefner outside counsel for Tri-State. The substance of our application, including how the SPP RTO meets the criteria in the statute and the rules, is covered in substantial detail in our written filings, which I'm not going to attempt to summarize here. Instead, I just want to briefly call attention to what I think are three key framing points for our discussion. First, that Tri-State has been working toward SPP participation for many years now, predating actually both Senate Bill 2172 and the Commission's rules on organized wholesale markets. Tri-State first became a member of SPP in the Eastern Interconnection in 2015 and started taking formal steps toward membership in the Western Interconnection in 2020, which is to say this is not a new effort for Tri-State and instead represents many years of effort as well as participation in multiple proceedings before this commission regarding its efforts. Of course, adding to Tri-State's own extensive efforts to pursue participation, we believe it's important to emphasize that the Colorado General Assembly has directed Tri-State specifically in addition to the other transmission utilities to join an RTO or ISO, meeting the OWM characteristics no later than 2030, which is coming up relatively soon here in utility years. As of today, SPP RTO is the only such market Tri-State could feasibly join. The second framing point is that while Tri-State is the only entity with a full OWM application before the Commission, it's not at all alone in its effort to join SPP RTO in the West. It is part of a coalition of 7 Western utilities and transmission providers, including Colorado Springs Utilities, Platte River Power Authority, Basin, Deseret Power, the Municipal Energy Agency of Nebraska, and the Western Area Power Administration, who have all committed to join the SPP Western expansion in 2026. While these other entities were not required to file with the Commission, we believe it's important to recognize that Tri-State is just one member of this larger coalition that has been working extensively together to facilitate the expansion. We also want to note that by design, this application does not cover Tri-State's entire system. In Colorado, it covers only the load and resources within the Western Area Colorado-Missouri Balancing Authority, or WACM, run by WAPA. And as we explained in the application, the fact that WAPA is Tri-State's balancing authority for this part of its system means that absent some type of extraordinary measures, Tri-State's load and resources in that BA must follow into whatever market structure WAPA decides to join, and in this case, that is the SPP RTO. Third and finally, as you mentioned at the outset, Chair, this is a deliberately abbreviated proceeding. Under the applicable rules, the Commission created a streamlined process for generation and transmission cooperatives that narrows both the issues and the discovery procedures to 3 core public interest criteria around greenhouse gas tracking, generator interconnection, and market seams. Tri-State's filings were largely tailored within that framework, and we have provided all of the information the rules require. That said, there are, of course, some details regarding SPP RTO that will continue to mature and evolve through and after market entry. But we believe all the elements for a Commission determination are before you today. As such, our ask is that the Commission evaluate the record before it against the specific criteria in the rules and find that Tri-State's plan to transition its WACM load and resources into the SPP RTO is in the public interest. I have with me this morning the 3 witnesses supporting Tri-State's application: Mr. Dan Walter, Vice President, Energy Markets, Ms. Lisa Tiffin, Senior Vice President, Energy Management, and Mr. Ryan Hubbard, Vice President, Transmission Planning and Policy, and all 3 are available to answer any questions you might have. So thanks very much.
I guess my preference, I think, would be to go through all the statements and then ask our questions at the end. Would that work for you guys? And so, but if you have clarifying questions to ask of Mr. Hefner, please go ahead, or we can keep moving. Commissioner Goldman, preference?
Nothing right now. We can do it at the end.
Okay. That work for you, Commissioner Plant?
Yeah, that works fine.
I guess next on my list is trial staff comments you'd like to share. Dr. Dalkey.
Morning. Morning, commissioners. Yes, my name is Stephen Dalkey, and I am offering some brief verbal comments here on behalf of trial staff of the Colorado Public Utilities Commission. So as you know, we submitted a detailed set of comments in this proceeding, and I'll just take this opportunity to briefly summarize some of the key points of our response for the commission and the public's benefit here. So Tri-State requested in its application that the commission make a finding that the SPP-RTO West is a statutory organized wholesale market pursuant to Senate Bill 21-072. Staff's primary recommendation is that the commission not make such a finding at this time. We've come to this conclusion because Tri-State unfortunately did not provide sufficient information into the record that we believe is necessary for the commission to make an informed decision, despite multiple information requests. We provide in our written comments a list of 6 important categories of information that are missing from the record, but we believe are important and necessary for the commission to make informed determinations in this proceeding. These include the costs that Tri-State has and will incur to join SPP, including but not limited to upfront implementation and transition costs, as well as ongoing fees for market participation. There's no information in the record regarding what it will cost Tri-State and its Colorado customers in joining this market. We're also missing membership and commitment agreements that Tri-State has entered into as part of its membership with SPP that detail contractual terms regarding its participation, and some important information about SPP's resource adequacy requirements, transmission assets that will be transferred into SPP, and the economic benefits studies Tri-State cited quantifying its the benefits of joining SPP. And all of these are explained further in our written comments. We also explain how in our information requests, Tri-State objected to many of them and alleged regarding costs, for example, that its costs to join SPP are, quote, not a relevant or permissible topic for discovery in this proceeding, end quote. Throughout the discovery process, we did explain to Tri-State that Colorado statute requires that an organized wholesale market must improve customer savings benefits to Colorado customers, and that the commission cannot evaluate customer savings benefits without knowing what costs Tri-State will incur when joining SPP. Regarding resource adequacy, Tri-State alleged that, quote, planning reserve margin and loss of load expectation studies for SPP are not relevant or permissible topics for discovery in this proceeding, end quote. Tri-State repeatedly objected to providing requested information throughout the discovery process in this proceeding to all the parties. And all in all, Tri-State objected to 49 of the 50 discovery requests it received from parties in this proceeding. All of this leaves the commission in the position of not being able to make adequately informed determinations. In spite of the information that's missing from the record, we did provide in our written comments a detailed preliminary analysis of the SPP RTO against the 10 statutory OWM criteria defined in Colorado law. Our analysis uncovered a few important nuances for the commission's consideration, particularly regarding Colorado's statutory requirements for operational control separation and governance independence. However, we don't think these particular issues are necessarily showstoppers in their own right, but the statutory independence and separation of control requirements, we feel, do raise some legal questions that are worth considering further as you interpret the statutory requirements and make your determinations regarding the SPP RTO. In addition, we provided in our comments additional analysis regarding the interconnection queue, as well as transmission planning and cost allocation within SPP. But I must emphasize here that all of our findings are preliminary and contingent upon further review of the important information that is currently missing from this record. Tri-State's discovery objections has unfortunately left the commission in a position where we don't believe it can properly evaluate whether the benefits of joining SPP will materially exceed the costs, nor whether participation meets Colorado's statutory requirements or whether the terms of Tri-State's participation is in Colorado's public interest. Therefore, before making any of these determinations, we recommend that the Commission order Tri-State to provide the missing information listed in our comments and provide parties a reasonable time for additional review and response. And thank you for the time. That concludes my prepared verbal comments.
Thank you, Dr. Dalkey. Next on my list was UCA.
Good morning, Commissioners. Can you hear me okay?
We can.
Great. Good morning, Commissioners. My name is Leslie Henry Sermos. I'm a rate and financial analyst for the Office of the Utility Consumer Advocate. Thank you for the opportunity to speak with you today about Tri-State's request regarding their expanded participation in the Southwest Power Pool Regional Transmission Organization. I want to start today by stating the UCA has been deeply involved in watching Western market development unfold, both with SPP and the Regional Organization for Western Energy, or ROE. And here's the thing, we're really in the early innings here. While there's been a lot of productive discussion and we're starting to see a vision take shape for Western markets, we honestly don't yet have a clear picture of what the benefits will really look like. We've commented at the FERC level on SPP's expansion into the West Interconnect, and we'll be refiling those comments in this proceeding for your review. Today, I'm here largely to echo what parties like staff and WRA have stated in the written comments. Our main message: let's pump the brakes a little. We're asking you to take time to really compare the options that are developing out West. Bottom line, UCA believes it's premature to determine that SPP-RTO is a statutory OWM, and it's equally premature to say that Tri-State's expanded participation is in Colorado's public interest. Why do we say that? Well, there are real uncertainties in Tri-State's application, and frankly, there's been significant movement on the ROE front where we urge you to pay attention to. The written comments have laid out substantial questions about resource planning and adequacy, about costs and benefits to customers, about RTO governance, and about greenhouse gas emissions tracking. Rather than rushing to make a public interest determination in statutory organized wholesale market binding, based on what we've considered a pretty thin record, we think the Commission should recognize something important. You've got time. The 2030 deadline for the organized wholesale market participation gives us room to get this right for Colorado. So UCA would like to recommend to the FERC both your public interest determination and your statutory OWM determination until you have the information that trial staff had identified in their comments, and until we all have a better understanding of how these dynamic and evolving Western wholesale electricity market efforts are going to shake out. Today, I want to highlight two specific concerns for UCA. First, the applicability question. Black Hills has raised an interesting point. While not taking a position on whether Tri-State's SPP participation is in the public interest, Black Hills is asking that if you find SPP-RTO meets the OWM requirements for Tri-State, that finding shouldn't automatically bind them or any other utility. We have similar questions, but we're coming from a different angle. Once you determine that an RTO is in the statutory OWM for one utility, does that make it materially easier for other utilities to apply, to approve it's an OWM in their own cases? Black Hills wants to make sure that the determination isn't binding for them. But frankly, we're concerned that an OWM finding here could create a path of least resistance for Colorado's other utilities to join SPP-RTO, even if there are better alternatives down the road. We need clarity here. Is the statutory OWM determination completely a case-by-case for each utility, or will utilities be able to lean on previous determinations? And how does that determination for investor-owned utilities under Rule 3754A differ from determination for co-op electric generation and transmission associations under 3754D and E? We're urging you to carefully draw the lines between the public interest determination and the statutory OWM determination. so that everyone, parties and utilities alike, understand what's generally applicable and what gets decided case by case. Second, we need a comparative analysis. The landscape is changing, commissioners. Recent developments in the Western energy markets need to be part of how you're thinking about that 2030 deadline. ROE is incorporating in 2026. It was established specifically to create an independent organization that can manage Western electricity markets, and it was designed from the ground up to ensure robust state and public interest participation in Western wholesale market governance. The alternatives for statutory OWM compliance are coming into view. With several years still on the clock before 2030, we don't think you should rush into a statutory RTO determination when you could have opportunities to fully evaluate alternative markets that may actually be better suited for Colorado's needs. Finally, even if you believe Tri-State's expanded SPP participation is in the public interest, you don't necessarily have to find that SPP is a statutory OWM or waive compliance with the statute. Under Rule 3754E, utility participation in an RTO or ISO that doesn't qualify as a statutory OWM could still be determined in the public interest if it satisfies the characteristics of Rule 3754D, I through 3. This is a lower bar, and it only applies to co-op electric generation and transmission associations. You could use this pathway to approve Tri-State's SPP's participation, even if you're not really to call it a statutory OWM. If you go this route, though, we strongly recommend that you do not waive the 2030 requirement to join the statutory OWM. You can always revisit this question down the road when Tri-State can provide more information to clear up uncertainties, whether about SPP being a statutory RTO or whether the requirements should be waived, or if Tri-State should be looking at other alternatives. UCA appreciates the opportunity to raise these concerns, and we generally support trial staff's recommendation to defer a decision on whether SPP RTO is a statutory OWM and whether expanded participation is in the public interest. Let's wait until we have real insight and concrete answers about how the wholesale market in the West are going to evolve. Thank you for your time and your attention.
Thank you, CEO.
Yes, thank you, commissioners, for this opportunity to provide comments today. My name is James Lester, Senior Advisor with Colorado Energy Office. CEO's interest in this proceeding is to ensure that utility participation in any organized market advances Colorado's state energy and climate policy goals. Today, we want to express our concerns that, as currently structured, SPP RTO may not meet those goals and may also fail to meet the definition of an OWM. Our major concern is that SPP's mechanism for tracking and reporting GHG emissions is critically vulnerable to federal preemption and regulatory reversal. Colorado law requires that an OWM must not significantly impair actions taken by public utilities to meet emission reduction goals. However, by embedding this state-specific policy within a federally regulated tariff, any Colorado utility joining SPP RTO subjects Colorado's climate compliance strategy to the authority of the Federal Energy Regulatory Commission, or FERC, and the political volatility of federal environmental policy. In our comments, we outlined a series of recent and ongoing federal actions that create regulatory uncertainty and threaten the stability of these protocols in our comments. I'll be happy to answer any questions you may have about these specific actions taken by the federal government, but they are available in our comments, and I don't need to repeat them here today. So just to quickly conclude, our office is concerned that the potential for federal preemption and regulatory reversal presents an unacceptable and unwise risk at this time. This could leave the state without a reliable mechanism to achieve its climate goals. When you also include our concerns in our comments about the governance structure of the SPP RTO, and combining that to our concerns about the federal impacts to GHG emissions tracking, CEO does not believe this RTO meets the statutory definition of an OWM, and that any utility in Colorado joining SPP RTO at this time is not in the public interest. I'll just leave my summary of our comments there, and we'll be able to answer any questions the commission may have.
Interwest.
Yes, thank you, Chairman. My name is Chris Leger. I'm an attorney with the Interwest Energy Alliance. I have no plans to repeat our written comments, but I wanted to emphasize one key point. A waiver should not be requested or granted into perpetuity. The obligation to join an OWM was written into law, and utilities have that obligation beginning in 2030 and lasting into the future. If no OWM exists in 2025 or 2030, this obligation that is in law does not cease to exist. The obligation continues unless and until the legislature revokes that obligation. A waiver of a legal obligation should not be granted lightly, and absolving a utility of its legal duties in 2035, 2040, or even 2060 in 2025 would be doing a disservice to both the spirit and the letter of the law. If this commission issues a waiver, we implore the commission to issue that waiver for a set time frame, which would do two things. It would incent Tri-State to provide pressure on SPP to align with Colorado OWM requirements, and would appropriately require Tri-State to bear the burden of making a filing to extend the waiver. I'm happy to answer any questions about this waiver or any other issue in our written comments when the time is appropriate, and that's all I have for an opening statement. Thank you.
Thank you, Mr. Leger. Black Hills, any comments you'd like to share?
Thank you, Mr. Chairman. This is Greg Sopkin for Black Hills. As you know, we have no opinion on Tri-State's requests in this proceeding as it is applicable to Tri-State. Our comments were very limited, and they were that there should be no collateral estoppel or res judicata effects to other utilities, non-Tri-State utilities, if the commission finds that the SPP RTO meets the definition of an organized wholesale market. Our main concern is when you look at the statutory standard for waiver or delay under 40-5-108 Roman 2, it states that the utility must show, number one, reasonable efforts to comply, and that there's no viable and available OWM. I'm paraphrasing here. And the word is and, not or, in the statute. The second element is the commission determines that requiring the transmission utility to join an OWM is not in the public interest based on the commission's evaluation of certain factors. As an aside, we believe that and really should be an or. That may be an argument we make at some point in the future. It doesn't need to be decided here, but if it does mean and, it means that first standard, that first prong, reasonable efforts to comply, no viable and available OWM, we would not like that argument taken away from us if we choose to make that argument in the future. In terms of the word viable and available, we think that's probably utility specific. And so again, we don't want any collateral estoppel effects. Some of the OWM criteria, the 10 criteria, do also appear to be utility specific. Specifically increasing economical supply options for customers, improving emission reduction and customer savings benefits to customers. Again, Tri-State in this case has put forth evidence about its own customers. I don't believe that that is necessarily applicable to all Colorado customers. So that's really the extent of our comments, and happy to answer questions. Thank you for your time.
Thank you, sir. WRA.
Good morning. My name is Sydney Welter. I'm the Regional Markets Policy Advisor with Western Resource Advocates. WRA is represented at this hearing by myself and my colleague Parks Barroso. Tri-State's request for a public interest and statutory OWM determination for the SPP RTO presents several issues of first impression. This is the first time the Commission must grapple with these statutory requirements of Senate Bill 2172. A well-designed, transparent market that complies with Colorado statute and rules can yield significant benefits in emission reductions, cost savings, and coordinated transmission planning. It's worth emphasizing that the SPP RTO is a separate market from Markets Plus with different market design features and market participants, including participants that are not supportive of Colorado's climate policies. WRA recommends that the Commission find at this time that SPP does not meet the 10 criteria to qualify as a statutory OWM, nor the 3 criteria for Tri-State's application to be found to be in the public interest, and therefore deny Tri-State's application without prejudice. The request in the alternative for a waiver should also be denied. Nonetheless, it may still be reasonable for Tri-State to join the RTO, and Tri-State remains free to join the market regardless of the decision in this proceeding. At this time, Tri-State's application and the SPP RTO do not meet the 3 public interest criteria in the areas of GHG tracking and accounting, generator interconnection procedures and agreements, and optimization between markets. As detailed in our comments, the SPP RTO also does not meet several critical OWM statutory criteria, including criteria number 7, as SPP's emission reduction and customer savings benefits are not proven, and criteria number 8, as SPP does not facilitate an inclusive and open stakeholder process. If any of these criteria are not met, the SPP RTO cannot be found to be a statutory OWM. WRA recognizes Tri-State's substantial efforts to improve the SPP RTO offering to bring it into compliance with these criteria, but at this point, the market still does not meet statute and commission rules. If the commission were to prematurely make a public interest ruling and find that the market qualifies as a statutory OWM, there is a risk of giving up influence over the future development of the RTO. In contrast, directing Tri-State to refile its application could preserve the Commission's authority and would give time for Tri-State, SPP, and stakeholders to continue to make improvements. Finally, no waiver or delay should be granted. The statute and the Commission's rules are designed to encourage utilities to make every effort to join a statutorily compliant RTO by 2030. The waiver rules are plainly structured to allow sufficient time for markets to mature as much as possible prior to a utility seeking to waive or delay the requirement. Ultimately, Tri-State has not provided the rigorous analysis required by rules for a waiver to be granted. Thank you, Commissioners, for this opportunity to provide WRA's perspective, and we look forward to answering any questions you may have.
Holy Cross. Is there, I don't know that Public Service Company file comments. Is there anybody from Public Service Company who'd like to offer comments? Is there anyone else who'd like to offer comments? Well, I do have some questions. Maybe I'll start with Tri-State. What do you guys think of the UCA proposal where Ms. Henry Sermas suggested that there could be a finding that it's in the public interest for Tri-State to join SPP RTO West, but perhaps delay the waiver finding or a finding that the market complies with the 10 statutory requirements. Any thoughts on what problems that might cause you?
You know, I think I would go back to the overall timing here. This effort has been underway for conservatively 5 years, in a lot of ways, much longer than that, stretching back to Tri-State's participation in the Mountain West Transmission Group. And, you know, I think that the danger of a delay is that Tri-State doesn't get the regulatory certainty that it needs to move confidently forward. You know, it has substantial software investments that it needs to make to finalize its participation in the RTO, you know, as well as lots of time and effort to do so. And I think the first order preference is, of course, just to get a clear decision that this satisfies the statutory obligation. That being said, I think a public interest finding probably, checks some of the boxes, and would certainly be better than a finding that it's not in the public interest.
I mean, but you do understand that this has all kinds of spillover effects for other utilities and market development, and given your approach to discovery, it's probably a limited record to deem the market as fully compliant with all the RTO statutory criteria.
If I could just point out briefly on the discovery concern, I mean, I certainly appreciate staff's comment. In our view, it's overstated. We responded to many of those 49 requests, and preserved our objection because they are outside the scope of what the rules that were only recently adopted say was fair game for discovery. But in many of those cases, and it's detailed in our response comments, we provided both an objection and an answer, in an effort to be collaborative. So to suggest that we essentially stonewalled on 49 of the 50 requests, I think is not necessarily a fair telling of how discovery was handled.
Just one more question along these lines. So if we were to go down the UCA proposal and deem it in the Tri-State's entry into the market as in the public interest, but wanted to delay the broader findings, waivers, and that it's a statutory OWM, is there any advice about how we can give you comfort to invest without maybe making a series of decisions that have a bunch of knock-on effects?
Yeah, I mean, I think one path is probably along the lines of what Black Hills has suggested, which is, carefully cabin the decision to Tri-State's particular facts and circumstances. It's certainly not our intention to set a precedent that's applicable to other utilities, to have any sort of preclusive effect on what other utilities do or don't do. Each utility is different. It has its own interests. Tri-State has really important interests here in terms of securing the substantial customer savings benefits that have been shown in all of the modeling, including the Commission's modeling to date. And our intention is to secure those benefits for our customers, and not necessarily to do anything that's going to foreclose other utilities from doing what they need to do in the best interest of their customers.
Just one more question for you. One of the criteria is sort of to better optimize dispatching unit commitment. We were getting there with the energy imbalance service market, where we had optimized dispatch across the two Colorado balancing authorities. And in some ways, this seems like a step backwards, that we're no longer optimizing dispatch across the, because you're going to be in SPP RTO West, Excel is going to be in Markets Plus, perhaps. So how do we optimize dispatch and unit commitment across these, and ideally reserve sharing? A lot of the benefits in this, for example, the staff analysis, we're putting the two Colorado balancing authorities together. Any comfort you can give me that this is gonna realize those benefits, given that we're not really optimizing necessarily dispatch and unit commitment?
Yeah, so I think I'm going to kick that question over to Mr. Walter, who can speak a little bit more in technical detail. I'll tell you the sort of high-level policy answer, which is making this transition into the RTO reduces overall the number of seams that Tri-State has to deal with. We're going from more seams to less, and we view that as a good thing. I think we have a lot of confidence in SPP's ability, for example, to deal with the seam between Markets Plus and the RTO with the RTDT tool, as well as the other efforts. But I think I'll let Mr. Walter speak in a little bit more detail to those.
Mr. Walter?
Yes, good morning. As was just mentioned, we do reduce for Tri-State a number, and the other participants in the RTO, a number of transmission owner seams and reduction of pancaking. So those are, additional benefits that a large portion of Colorado are going to get that they don't have today. As far as the efficient resource dispatch, the intent and the tool is being made because there are going to be two BAs, still two distinct BAs, whether is an what's called an RTDT tool, which is currently at FERC waiting approval. And it's an expansion of a current market method that SPP has in the East. So in the East today, in SPP, you can put in price-based bidding at the seams of the RTO on the day ahead for an hourly bid price. And it could be someone inside the RTO bidding to sell at a certain price outside of the RTO, or someone outside of the RTO bidding for the day ahead to bid something into the internal day ahead. That's an hourly product on the day ahead. The RTDT is a proposal to expand that, where you could put in bid prices effectively for the intra-hour 5-minute market as there is today. So in some ways, we'd be able to emulate what we're currently doing today in the WISE real-time market with SPP Markets Plus, SPP RTO, and the RTDT tool. The RTDT tool also would not be exclusively only something that could be between Markets Plus and the RTO. It could be between the RTO and any of its BA neighbors.
Well, when do you think these tools are going to be fully operational? Is it a year or 2 years?
To some extent, I have to defer to SPP. Again, it hasn't been approved at FERC yet. I would say my personal opinion is it would not be in place by the RTO start date. But again, SPP can override me, but I would expect it to be in place before the estimated Markets Plus start date.
Okay. Just one question for CEO, and then maybe one question for staff, and then I'll turn it over to you, Commissioner Goman. I guess, Mr. Lester, I understand there's all kinds of concerns about what the federal, the new administration is doing, but just going through your comments, I was struggling to see how it could, what the direct way where it would preempt Colorado's emission reduction requirements, or really screw up the reporting. It seems like Colorado is going to have access to the underlying hourly generation data, and even if they do away with the GHG link, it seems simple enough that we can calculate it based on sort of average emissions. So can you just help me understand the pathway where it really undermines what we're doing? I wasn't really seeing that in your comments.
Sure. So we do cite the proposed elimination of the greenhouse gas reporting requirements by EPA, which does impact utilities to a certain extent. However, as APCD has assured us, they do get their data from EPA's eGrid, which is part of the Clean Air Markets Division, which has not yet proposed to eliminate that. However, we just see this general trend, and especially if the administration is successfully able to overturn the emissions endangerment finding, that could give them free rein to eliminate all types of programs, particularly within the EPA and DOE, So I think that's a pretty sizable risk in our view. And I don't think it's particularly, we still might be able to get that data with Colorado utilities, but as we know, other states may not have that information available without eGrid being publicly available. So I think that's what our major concern.
But as I understand the Tri-State Public Service Company Air Quality Control Division letter, we will now get hourly generation data from the market by unit. And to me, that's the real core data we need. And it seems way better than the than the pre-existing eGrid or other EPA data, because you can look at it and see what's going on an hourly basis, and there's methodologies to attribute it out by load and source. So it seems like no matter what happens with the federal data, this positions us far better than the status quo, by unit, by utility, by load, to understand what's going on an hourly basis. So this seems like a way better path forward. And I'm not sure I understand how you see federal preemption, sort of undermining that piece of this market design.
Well, I think that points to another area of concern of us, and that's the independence of FERC. So these tariffs are approved by FERC, and I think a future commission could easily find that the entire market, SPP's GHG protocols, could be conceived as being unjust, unreasonable, or unduly discriminatory, based solely on having that requirement to report on GHG emissions in their tariff.
But even if that went away, we'd still have the data we need to ensure state compliance, wouldn't we?
Within the state, I believe we would. But again, the point of the market is to get energy and power from outside of our state. So we would not have that information from other states, particularly in the SPP footprint.
But we'd have the generation data, and couldn't we easily or pretty easily infer emissions data? I mean, the key is getting the underlying energy data. And that's what my understanding of this does. So yeah, you just put on an average emissions factor and you get to the emissions.
I think that would be ongoing discussions that we as a state should have with the experts at CPHE. And again, I think there's enough uncertainty and enough momentum at the federal level to make us want to pause on these decisions. I think there is possibility that you could be correct that even with all the federal actions, we could estimate emissions from other utilities, but that's not quite the same as the ability that we have now as to have a much better understanding of emissions from utilities across the country.
Mr. Hefner?
Just briefly, I think the point we'd want to make here is Tri-State is very clear that it is the entity with the emission reduction obligation in Colorado, not SPP. Currently in the APCD workbook, we have to report emissions from out-of-state sources using eGrid and other methods of ascertaining emissions rates. While some of the details would change in a market, we don't see that the process would be fundamentally different. Tri-State would still be the entity with the compliance obligation, and we would have to structure our market participation in such a way as to comply with our obligation. So just a minor point there.
I appreciate it. Just one more comment question for you, Mr. Lesser. It just seems like one thing this does between the Markets Plus and the RTO, SPP RTO West, is get a common set of methodologies, approaches, data across the two Colorado balancing authorities, as well as all the market participants, which seems like a good thing. I mean, it seemed like in the past it was just that, people could use, any individual utility could apply its own methodology. So any thoughts or comments on that?
Well, we don't know the final approved protocols for both Markets Plus and SPP RTO. Markets Plus is much further along, and I do understand that SPP RTO is going to be similar to Markets Plus. However, I think that's still an outstanding question of just how easily those will be applicable across both markets.
Ms. Tiffin.
Good morning, Chair. I just wanted to add that the protocols for greenhouse gas tracking and reporting were taken from the Markets Plus, the extensive Markets Plus work by all the participants, which I will say the West participants for RTO and all of SPP were very appreciative of all the work that went in there, and we were able to easily kind of bring that over into the RTO protocols. And those protocols for greenhouse gas tracking and reporting were approved earlier this year. And they're currently, we're working through the implementation process with SPP for the RTO.
Okay. Thanks for that clarification, Ms. Tiffin. And thank you, Mr. Lester. Just one question for staff, and then I'll turn it back to you, Commissioner Goman. Dr. Dalkey, given, just any thoughts? It seems like the balancing authority is driven by WAPA. It does seem like Tri-State's request for some form of regulatory certainty on a time frame that it may not control isn't unreasonable. I guess I'd just ask you about UCA's sort of backup position about giving Tri-State as much regulatory certainty as we can, but trying to leave the broader decisions about the market and knock-on effects for other utilities to the future. Any thoughts on that, or even, well, why don't you answer that, and then I'll give you a chance to respond to Mr. Hefner's characterization of the discovery dispute. But if you could start off with any thoughts on providing Tri-State regulatory certainty.
Sure. So I think we all know, kind of separate or additional to the 10 statutory requirements, there's 3 public interest criteria in commission rules upon which you can make a public interest determination, somewhat more limited in their scope on kind of three general topics. Where we ended up here today, I think our position in thinking about a public interest determination separate from a statutory decision, that the commission has a responsibility to be informed when it makes determinations in the public interest. The commission, we don't regulate Tri-State, and so we don't generally get all of the detailed cost information about their assets and their operations and so forth that go into those rates. And here we're kind of in between that, right? Tri-State doesn't need us to approve recovery of the costs associated with joining SPP, to pay SPP administrative fees, participate upfront. You heard Tri-State's counsel talk about the substantial software investments that they need to make to join. I do think this discussion needs to go both ways on this, right? Like the commission, nevertheless, I think should still be informed about what's going on regarding the market in making a determination around the public interest of the Colorado utility and their customers' actions related to that market. So I think my recommendation would caution against making a public interest determination in support of the market without some of this information. The route we're moving towards, we didn't described this in our written comments because we weren't sure if we would get some of this information, in Tri-State's response. Ultimately, we didn't. I think where we're at is we recommend. I think you should consider ordering some of the important information you might need to be informed in making a public interest determination. It doesn't necessarily need to extend out multiple years if we can get some cooperation or some transparency on some of these topics. But I think that's kind of how I would think about it and recommend getting the information that would just kind of make a more responsible decision.
And if you had to pick the top 5 things on that list with a clear understanding that we're not rate regulating this utility, and Tri-State rate impacts are their issue and their customers' issue, not really ours, what would those top 5 or top 3 information requests be?
Yeah, so the cost is at the top of our list. So I think it would be the upfront implementation costs and ongoing participation fees for participating in SPP. Some of that's probably known, and some of that's probably a informed going forward estimate, as well as cost estimates and some information around the investments that Tri-State has made or will need to make in terms of software, IT, personnel, et cetera, to become a market participant. It could be confidential if aspects of that are commercially sensitive, but I think the commission should probably get that information, not for the purposes of rate regulating Tri-State, but for the purposes of understanding the balance of benefits and costs to Colorado customers for this decision. Second on the list, we mentioned the membership agreement. I think Tri-State appeared to respond to this aspect of our comments in its response, stating that its membership agreement is fully consistent with the pro forma that SPP publicly posts. They made some comments kind of going towards that. So assuming that's true, perhaps an affirmation from Tri-State that the membership agreement contract they executed with SPP does not have any terms, that differ in any material way from the pro forma. Assuming that's the case, then I think we can take that one off the list as long as we have that affirmation. You said 2 or 3, so maybe I'll do 1 or 2 more. I think the commitment agreement is important, which is kind of, the commitment agreement could be important. I think that details a lot of the commitment terms that Tri-State kind of has already entered into and is on the hook for, whether, as part of its transition and commitment to join. It's kind of a separate contract. And then maybe there's some dialogue still around resource adequacy requirements and studies. We had some back and forth with Tri-State, and I think there was kind of some circularity in that discussion around not understanding what the requirements are, what studies were available and not, and the discovery process didn't help that. So that's 3 in response. So the cost and all the details I outlined, membership/commitment agreement, and then some clarity around resource adequacy requirements would be my top 3. But we do have that list of 6 in our comments if you want to review that and consider expanding upon those 3.
Mr. Hefner, any thoughts about trying to give staff a little more under appropriate confidentiality to protect any commercially sensitive information? I mean, you've already referenced in your statement today that you are seeking regulatory certainty around these costs. Seems like might be useful to disclose them. Thoughts about perhaps going a little further and providing the parties a little more information under appropriate confidentiality?
Yeah, I think I'd have to take that back and discuss it with my client. But I think certainly, if there's reasonable additional information we can provide that the commission thinks would be helpful, we're certainly happy to have that conversation.
I think, at least speaking just for myself, I'd appreciate it, given the sort of spillover knock-on effects. I think, as we struggle with providing regulatory certainty, but not over deciding things prematurely, I think providing the parties, even under appropriate confidentiality, could be helpful. Thank you, Dr. Dalkey. Thank you, Mr. Hefner. Commissioner Gilman, anywhere you'd like to go?
No, I mean, I really had a very similar question to what you just asked, Mr. Hofner. In terms of, it appears the company is asking for some regulatory certainty here at a minimum around public interest determination and a maximum around the OWM determination. But it seems as though we have several of the commenters pretty frustrated by the process, which puts the commission in a really difficult spot here to determine, how to provide you with regulatory certainty with lacking information that at least several of the commenters or parties think is necessary to make such determinations. So I don't know if that's questioned, but it was similar to what the chairman's saying in terms of,
it does suggest there's a second vote, maybe.
I guess a prodding, just an acknowledgement. Tri-State will be putting us in a very difficult spot unless or until you figure out if you can provide more of the information that was not provided, that was requested.
Understood. I think we hear where you're going, and Ms. Tiffin, I think, has her hand up. If we could call on her.
Ms. Tiffin.
Thank you, Chair, and thank you, Commissioner Gilman. We definitely hear you. I will, just to give a little background, I mean, I think Tri-State in general, in most of our interaction with our stakeholders and with the commission, we try to represent our cooperative principles, and we try to be very collaborative, and we, I think, typically maybe, are slightly annoying with our stakeholders in some of our proceedings with the amount of meetings and quantity of data that we do share. We took a different approach here because of the distinction for rules for the GNT, the wholesale GNT co-op versus the IOUs, and we tried to kind of adhere more closely to that, and that's why you saw a lot of it. Here's an objection, here's an answer in discovery, but we do understand that this is the first time, there are, this is kind of a big deal to be having this conversation about this rule and these criteria. And I certainly have heard and felt from some of the stakeholders that we have, I think, a pretty good relationship with their frustration today. So I think what we would like to offer is to go back on these key issues where there's a desire for some more information, to share that under the appropriate confidentiality level, likely a highly confidential level with PUC and UCA, and see if sharing that information at that level, if we can give you a little bit more comfort and give the parties more information, and certainly give the commissioners more direct access to all the criteria behind what we're doing here. So we would just like to offer that up as a possibility.
I presume perhaps trial staff as well, in that they had kind of the most detailed list. Yeah, I mean, just that would be very helpful to where we're going here. I think trying to ensure that whatever goes on is in the best interest of Tri-State's customers and their customers. And that's what we've been tasked with here. So we're in a, and on the one hand, I very much respect that this is an effort Tri-State's been involved in for a long time, and this isn't new, but that also perhaps breeds more skepticism as to why some relatively basic information can be provided. So that is like kind of helpful and kind of not helpful, I think, to the cause that you all have been working on this for quite some time.
Yeah. And agree, trial staff as well. So trial staff, PUC staff, and UCA.
I think we're all trying to catch up, so help us.
Yep.
Commissioner
That's all I have right now.
Okay. Just one more thing on that, and I'll turn it over to you. Mr. Hefner, Ms. Tiffin, Dr. Dalkey, The deadline in my script for comments is October 24th to help us keep on schedule. So hopefully this can happen quickly and maybe informally. So that sort of deadline we were shooting for final written comments. So pretty aggressive, but just throw that out there. Commissioner,
we will push out the supplemental information as quickly as we can.
all right. Commissioner Plant, anywhere you'd like to go?
Thank you, Mr. Chairman. I don't have any further comments for the company except to, yeah, I think, Mr. Chairman, you just said maybe informally. I think maybe formally we need the record to reflect some of this information in order to base any kind of a decision on the record. And so I would want to make sure that it is a part of the record in that way. I did have a question for Mr. Lester, and wondering if he could join us here. So, Mr. Lester, I get your concerns around the GHG commitments under FERC jurisdiction. My issue is that that's going to be true of any organized wholesale market, and so we have these competing issues. And I'm wondering if you could give us your take on this. We have a competing issue of a statutory requirement to join an OWM by 2030 and the retreat of federal government from environmental protections and really attacking some of the legal basis for making those determinations. So how do we address these sort of competing issues of a statutory requirement around 2030, which, I mean, this administration anyway is going to be in there until 2029. So how do we look at trying to comply with the statute while also recognizing that we have this issue with the federal government?
Yeah, thank you, Commissioner Plant. That's a very good question, and I think it's very similar to how we approached this discussion in the Public Services Application for Markets Plus. You know, it's really such uncertain times. We know that many of these issues, so for one, the independence of FERC, if it will be played out in the courts along with many of those other federal actions. So it will take time, but that's why we're really, our office is certainly not against utilities joining organized wholesale markets. We support the statute. We want to see that continue based on the benefits that they will provide Colorado ratepayers. And I just think we need to, our position is that we should be pausing these decisions until there is more certainty. Now, of course, we don't have an exact timeline for that certainty, which I know is difficult for all participants, particularly the utilities. But I think we just identify many areas where the federal government could impact our climate goals and basically even our ratepayers if they are managed to keep expensive coal plants online for longer, and even subsidizing them through billions of dollars that they've recently proposed. So these are all issues where we just think that despite the commitment of 2030 in statute, we do need to take a little bit more time. That's our position. And I think you saw that play out in the recent California legislation, where they were very concerned about a potential market that would expand outside of California would be subject to these federal changes and policies that would impact many of the Western states' climate and basically reliability goals. We need to continue to build more energy to provide reliable power to Colorado. And we think that this administration is doing a lot of things that's preventing us from doing that. So yeah, I wish we had a specific deadline where we could say by this date we will be certain, but we know everything is uncertain. So that's why we're asking for a pause in these proceedings.
Is there any kind of an alternative pathway of specific data that would go into a specific system that would ensure that we have the information that we need to ensure compliance. Recognizing the uncertainty around what the federal government's going to do, also recognizing that they have jurisdiction over these organized wholesale markets. Is there a component of a contract where we can make sure that there is a commitment to providing a certain type of information to, for example, CDPHE or some entity that can acknowledge compliance, and also that we can rely on for our emissions approvals, because it is pretty integrated into the overall state system, including various different waivers and things.
Yeah, I don't think I quite have an answer for you for that right now. I think it would be very important for the state agencies to continue to work together, particularly with CDPHE and their staff experts on pathways forward. As Chair Blank mentioned earlier, there's the potential of estimating emissions, whether that's not going to be effective enough to really be reliable enough to account for emissions outside of the state that get imported into Colorado, I think is something that we would need to pursue with the relevant state agencies, and along with the utilities as well, get their input as well. I think that would be an important step moving forward.
Thanks. And another comment that was in your testimony was around the overwhelming impact of the transmission members on decisions within the RTO West.
Mm-hmm.
Is that an uncommon structure as it relates to RTO governance or ISO governance?
It's not. Looking at the RTOs across the country, obviously with the exception of, say, California and ISO and New York ISOs, which obviously have state representation because they represent only states, I think there's a lot of concern about governance structures and the ability for transmission utilities to kind of have a great control. And that's an interesting part of the statute that really expressly intended the state and interest in the state to have more of a role in transmission planning. And I don't think any of the markets that represent a variety of states really would meet that standard for OWM to meet the OWM criteria as we stand now. You're seeing that play out here now in PGM with states really trying to get more input into the planning process. From my understanding is MISO probably does it the best, but looking at it, I'm still not sure that even MISO would meet that criteria, that pretty stringent criteria in Colorado statute.
Does the Energy Office have any recommendations of what would need to change within the RTO governance structure in order to achieve that sort of statutory compliance? Because it sounds like, as you said, right now, nobody does. And obviously we have this sort of time frame, and we have a requirement in statute. If it's determined that nobody meets the OWM requirement, then the utilities can just apply for a waiver. And I just what are the steps that can be taken in order to ensure that we can achieve compliance?
Yeah, I don't believe I have that answer for you today, but I think we could certainly try to address that in our response, our post-hearing comments. It is interesting to think about what the drafters of the legislation were anticipating, and in my opinion, they expected a brand new market to emerge in the West, a single market that would encompass a lot of areas, and that governance structure could be built into that brand new market. That's my impression. I'm not sure if that's the case or not, but I think that might have been why this was such a stringent requirement. But it is something that we can address.
Time frame for a brand new market to get created.
Well, now because we're we're halfway through 2030 from when that statute passed. So yeah, things have gone slower, but as we all know, 2030 seems like a long time away, but in utility years, it's not long, and regulatory years, it's definitely not very far away.
Understand. Thank you very much, Mr. Lester. I appreciate it.
Thank you.
Thank you, Commissioner Plant. I just had one follow-up question, Mr. Lester. Commissioner Plant brainstormed with you that if only there was an approach that could deal with all the GHG tracking, accounting, modeling issues, but isn't the letter with Tri-State Public Service Company and the Air Quality Pollution Control Division pretty close to that? Can you just help me understand why that letter doesn't pretty much give Colorado everything it needs, and it's already been blessed and signed by the Air Quality Control Division? I mean, that is what Commissioner Plant was requesting to me, unless you have specific shortcomings or concerns with that letter and approach. It does the resource mapping. It does common dispatch methodology. It allocates emissions on an hourly basis. It gets the data. It links the generators to the load in real time, and it's binding across both markets and the market participants. So can you help me understand why that isn't exactly what Commissioner Plant was looking for?
Well, again, pointing to our comments, in fact, we actually filed a letter of support when that proceeding was open, and this was in 2024. And that was prior to all this information coming from the federal government about, their desired ambition to eliminate GHG emission accounting from basically from existence. It seems to me. I think we've identified several different ways where the federal government is going to attempt to restrict that, including having the Attorney General go after our state's emission policies. Again, as I mentioned to Commissioner Plant, if we had a timeline on when these would be, certain or uncertain or denied by the court system, I know we would be much more comfortable setting a deadline. But as we all know, this could go on for a few years, and that's why we're suggesting a pause.
And I guess just one last thing, I get they could come up with some creative solution that we haven't seen to somehow preempt state emissions controls. But on the reporting and tracking, it seems to me if you have the underlying data on dispatch by unit, by load, by hour, you can infer emissions very easily, independent of what they do to the rest of the GHG reporting, because average emissions per unit of generation. So at least on the reporting and tracking, is there any reason you're uncomfortable with what we have here that I'm somehow missing and didn't see in the comments? I mean, all you need is the underlying dispatch data and you can infer emissions.
Right. Yeah, like I mentioned to Commissioner Plant, estimating emissions from states outside of Colorado would need additional kind of discussions with state agencies and utilities to ensure that they are particularly comfortable. I say they, I mean the Air Quality Commission, who really is the most expert and responsible for that tracking. Just so it would be another, not necessarily new round of that M docket that was opened in letters of support, but it would require additional discussions to ensure that in case, say, the eGrid data, in case EIA stopped tracking, that we would have reliable estimates because they would be estimates of emissions.
That's all I had. Commissioner Gilman, any follow-up? Anything else?
Nothing additional, thanks.
All right. I think that's all I had. If the parties could be prepared to get comments back to us by October 24th, I think that would be most helpful to us to keep on the schedule. Mr. Crakes?
Yeah, Mr. Chairman, I just wanted to get some clarification on that October 24th date. Is the idea that Tri-State will be providing supplemental information before that date such that the parties would respond to it by October 24th? Or are we kind of just filing supplemental comments, not knowing what that additional information would be?
I'm hoping Tri-State gets you the additional information very quickly, and we can incorporate that additional information by October 24th. But Miss Tiffin may be correcting me, Miss Tiffin.
No, I just wanted to say that we're going to work to get all that information out to parties, to the appropriate parties by the end of this week.
So then if you guys could process that and incorporate it into your comments by October 24th, that'd be great.
And then just one further clarification, Mr. Chairman. There isn't anything on the procedural schedule about these comments, so I just want to clarify what they are. Are you looking for like an SOP or just further subject matter expert comments like the ones we filed previously?
Yeah, it's not, I mean, if you just have anything else you'd like to share with us based on what you heard today, what you heard from the commissioners, what you heard from the other parties, what you find out in the data, that would be the deadline for us to process it as we make our decision. I mean, so that's the purpose.
So
just
informal comments are fine.
Yeah.
Okay.
Yeah.
Thank you, Mr. Chairman.
Mr. Barossa.
Yes, thank you, Chair. A few more clarifying questions. I just wanted to confirm that the additional.
I like asking questions of you guys. I like when you're asking us.
And maybe this is a question for the utility as well, but wanted to confirm that the additional information being provided at the end of this week will be shared with all parties to the greatest extent possible, and that it will be provided publicly. And if not, because this is a litigated proceeding, WRA and other parties have filed highly confidential NDAs, and so I would expect that parties that have filed the appropriate non-disclosure agreements are able to view highly confidential information that's provided this week.
Ms. Steffen? Or maybe Mr. Hefner.
Yeah, I may defer to Dietrich on this. I can say from the business perspective, what we will do is look at what we're going to provide. If there's any reason why we would need to limit it in nature, then we would, our legal would work with the parties and let them know kind of where we're drawing a line. But I hear what you're saying, and to the extent that there's information that we have that we can share under the confidentiality agreements that we have in place, we will do that.
Yeah, I would just add maybe a slight wrinkle, which is, we'll have to take another look at what our protective order says. And we will work as closely with the parties as we can to get agreement on any edits to that, get a new motion in and try and share what we can, understanding that some of this is pretty sensitive.
Appreciate that, Mr. Hefner. Thank you.
Thank you. Ms. Kohlroos-Ruman.
Thank you. I was just going to reiterate that CEO would also like to see that information as possible, but it sounds like that will be shared with all the parties, and we're happy to file any necessary additional NDAs or anything like that. So thank you.
All right. Anything else before we adjourn? Are there any public commenters who would like to share their thoughts? All right. With that, I'll ask you guys anything final before we adjourn? Yep.
Nothing for me.
All right. Thanks all for the conversation, the dialogue, really helpful to me, and we're adjourned. Thanks, everyone.
Thank you.